How complex is space law for private ventures? Have you ever wondered how private companies can legally operate in space? The world of space law is filled with twists and turns that can leave anyone scratching their head. Let's break it down and see what makes it so complicated. Space law for private ventures is not straightforward. It is shaped by a mix of international treaties, national laws, and changing regulations. The main framework comes from international agreements like the Outer Space Treaty. This treaty says that countries are responsible for the actions of private companies they oversee. However, it was created with government entities in mind, which leaves many gaps when it comes to private businesses. At the international level, the Outer Space Treaty requires countries to authorize and supervise private space activities. But it does not clearly define what national activities or non-governmental entities mean. This lack of clarity makes it tough to enforce rules. As a result, private companies often find themselves in a gray area, with different countries interpreting their responsibilities in various ways. This inconsistency can lead to a confusing legal environment for businesses. National laws play a significant role in regulating private space ventures. Countries like the United States, Luxembourg, Japan, the United Arab Emirates, and Australia have created their own laws to manage commercial space activities. For instance, the United States Commercial Space Launch Competitiveness Act allows companies to keep resources they mine from asteroids. However, this raises questions about whether this complies with the Outer Space Treaty, which prohibits claiming celestial bodies as national property. The differences in national laws create a fragmented system that can lead to legal disputes. Private companies also face practical challenges. Getting licenses to launch or operate in space can take a long time and varies greatly from one country to another. Liability issues add to the complexity, especially for missions involving multiple parties from different countries. For example, rideshare launches, where several payloads share a single rocket, requiring detailed agreements on risk sharing and insurance. These arrangements can be tricky to navigate under current laws. Environmental regulations add another layer of complexity. Companies must follow rules to protect the space environment, including measures to reduce space debris. This is vital for the safety of current and future missions. The complexity of space law impacts how private space missions are planned and executed. Legal requirements shape mission design, safety protocols, and operational procedures. Astronauts on commercial missions must work within the limits of licenses and liability frameworks set by national regulators. This legal backdrop influences the training astronauts receive, focusing on compliance with regulations and risk management. In summary, space law for private ventures is complicated due to the mix of international treaties meant for states, varying national regulations, and emerging challenges. This complexity directly affects how private companies and their astronauts prepare for and carry out space missions, making it essential for them to navigate a challenging legal environment alongside the technical demands of space travel.